Hello, welcome to Law Awareness Weeks at CDC 2022. It is a collaboration between Law Society Pro Bono Services, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, and the Singapore Corporate Counsel Association Pro Bono Chapter, supported by the People's Association. I am Serene Gan and am your host for this webinar. Today's webinar is, so you want to be a social media influencer? Before we start, some housekeeping matters. Today, we will be using Pigeonhole Live for our Q&A session. You can submit your questions at any time during the webinar and also upvote on any questions that may interest you. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Next, key in our event passcode, which is LAWCDC07, as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole. If you are viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. Please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. And with that, I would like to introduce our panelists for today's webinar, Cho Pei Lin and Fong Wei Li. Pei Lin is a pioneer in introducing litigation PR to Singapore. She provides strategic PR consultancy in public affairs and public education campaign communications, crisis communications, and government relations. Pei Lin is an accredited PR practitioner of the Institute of Public Relations Singapore and has a law degree from the National University of Singapore. Wei Li is experienced in commercial and civil litigation, arbitration, and mediation. He is an active member of the Law Awareness Committee. He is often invited to conduct public talks and seminars aimed at promoting legal knowledge and awareness among laypersons. Besides practicing law, Wei Li lectures on a part-time basis at the Singapore Management University's School of Law. Thank you, Pei Lin and Wei Li, for joining us today. Moving on to our scenario for today. Belle wants to be an influencer and starts posting content. She shares photos, media of her day-to-day life and of her family and friends. Her mother told her that she's uncomfortable with the family photos being displayed publicly online. Belle feels that she should be entitled to post whatever she wants. Wei Li, from a legal perspective, is Belle permitted to post and say whatever she likes about her family and friends?
Hi, Serene. Hi, Pei Lin. Okay, so this is a tricky question. We get asked that very often. And this question comes up very frequently because we do a lot of selling and marketing online right now. And a lot of online content really attracts eyeballs because of images, because of videos, because of photos, right? Now, whether or not she's allowed to post photos of her families and friends depends on whether or not she registers and runs her business as a corporation or as a private limited. If she runs the business, she takes on endorsements, she promotes products, she receives payment as a private limited, as a company, then she's bound by the Personal Data Protection Act, right? I think a lot of you will be familiar, truncated often into the PDPA. What the PDPA says is this: if you are a business, if you are a company, you have a duty to protect the personal data of the people whom you collect such data from. And personal data is given a very broad definition under the PDPA. any kind of data that allows you to be identified amounts to personal data. And I think it's not difficult to see how a photograph falls under the definition of personal data, right? So back to basics, if she runs the business as a company, of course, she's got an obligation to protect the data, i.e. the photographs of the family, unless of course they give consent, right, to their photographs being used. But if she is running her business as an influencer solely as an individual, she doesn't, so to speak, register her business, or she doesn't take payment, or conducts activities under the guise of a business, then ironically, some people would say she's not going to be bound by the PDPA, and as a result, she technically has no legal obligation to not use the photos, provided the photos are taken by her. Okay, this delves into another different area of law concerning copyright altogether, but I think we can shelve that and talk about that later if we have time. Perhaps let's hear from Peilin to see what Peilin has to say about this issue.
Yes, Peilin. Yeah, we're curious to hear what factors or what things you think Bell should consider. I mean, it seems like the law is saying that if you're an individual and not a company, you don't really need to comply to PDPA. But surely, you're going to have such an unhappy mother. Peilin, what do you think?
So I think it's not just about legal perspectives, but really one has to look at the relationship, right, that you have with your family and friends. The reality is that if somebody in the family or amongst friends is taking photo during dinner or a gathering and start posting them online, and somebody in the family say, look, I'm not comfortable, just don't post my photo, but that person continues to do it, you usually end up, for example, if it's friends, people saying, I'm not going to turn up for a gathering with her because she goes around taking ugly photos of me or photos of me, and then she go post it online, and I do not appreciate my photos appearing online like that. Now, if it's his family, it really depends whether her mother will say, I no longer want to have dinner with you. But even if she continues to have dinner with her family, very likely in our day-to-day, we will notice that family members who do not want their photos taken will either do this or will be very grumpy, if especially for children, right, or teenagers. If you say must take, then they will give you a very black face, and they probably then don't look so good on your social media platform. So I think it is important that people's permission are given or obtained, and if you take a photo where it's very clear that person is trying to avoid and you post it online, the likelihood is that your followers or fans will probably spot it and then may judge Belle as someone who is posting photos against other people's wishes, and as a result may not like her very much as an influencer as well. So these are the things that Belle probably would have to consider.
Thanks, Peilin. I think the next part of the scenario, Belle also posts about her work online, and sometimes she complains about her company. Her work buddy thinks she should ask HR for permission, and Belle thinks, this is unnecessary, as it's her own life. Wei Li, what's your thoughts?
This one tricky. I'm coming from a very legalistic point of view, right?
Sure.
And she's got to be mindful, this Belle person, right? Because if she starts nilly-willy posting about work, she may inadvertently post or publish confidential information from the workplace. And that could be a serious breach of her employment terms and her employment contract. Most of us who have a job would have read or signed an employment contract in one form or another. And I think it's very, very common to see confidentiality clauses in employment contracts. And these clauses say, look, if you come across certain confidential information or secret information belonging to the company during your course of employment, you cannot divulge it to the public. So she's got to be very careful, right? Sometimes we don't intentionally go retrieve a piece of confidential information or secret information and then post it deliberately. But I mean, I can imagine a situation where she's at work and then she whips out her phone, takes out a TikTok story, or takes a TikTok story, or I mean, TikTok post or Instagram story about how horrible her work is. She puts up these, I mean, she posts about the contents of her monitor at work. And I mean, lo and behold, there could be a client list or there could be some sort of secret formula on her monitor. Right. So that is an obvious breach of employment contract. Some companies who are a bit more sophisticated do have internal guidelines and policies governing what their employees can post and cannot post on social media. Some companies will say, look, if it's work-related, if it's got to do with our product or services, you are not allowed to say anything about these things unless you get clearance from management, right? So if she works in one of those companies and she puts up a post talking about what she does at work or what happens at the workplace without first getting clearance from management, then again, she could run into potential problems or disciplinary issues at work. Yeah.
Thanks, really. Pilin, what are your thoughts on this?
I mean, you must be joking lah if you think that your boss is not on social media. So definitely, if a person is posting it privately, just to share with her best friends, that means on certain platforms like Facebook, you can actually select who the audience is, or even Instagram, you can keep your post private. But in this case, because Belle wants to be an influencer, the assumption is that her posts are all public. And I have received forwarded screenshots of my colleagues' posts. That means kind-hearted people or friends will screenshot and say, hey, I think she's talking about you, you know. and so if you are complaining about your company, expect your boss and your colleagues to read it. And I do think that to a large extent, performance assessment could be affected because you are complaining out loud. Whether you are able to prove it or not is besides the point, right? And your bosses need not even make reference to it. But it is a very silly thing to do. Yeah.
Thanks. Important reminder. Don't think your bosses cannot access social media. And even if they can't, or even if you think they don't, there'll be other people who will be very happy to spread on the information to them, as you say, like in a kind gesture.
I mean, people are watching you all the time, right? And it depends on whether or not you post it on your personal device or on the office, assigned device, such as an iPad or an office computer, because most big companies nowadays, they actually have monitoring software that detects every move you make if you are accessing the internet from an office, so to speak, issued device. I mean, we're living most of our lives, both personally and professionally, online right now. And with work from home, I think there is a more pressing, there's a lot more pressure on companies to monitor what their workers do in this age of working from home. So don't think that just because, I mean, Apeli raised a very good point. If you, put up something and you restrict the readership to your close circle of friends, the damage may not be that pronounced or the risk may not be that high. But I mean, again, coming from a very kiasi lawyer perspective, right? I won't say it's entirely risk-free also, because if you slip up and you put up the post using, let's say, the office laptop, even if it's closed off to a certain, inner circle of friends, people are still going to be able to pick up on the activity that you engage online. Yeah, so got to be careful.
Thanks, really. Important point. Yeah, your laptop probably is being monitored. Computer laptop is actually probably being monitored by the company, as well as your company internet as well, if you're going to log on to the Wi-Fi. We have an interesting question from an audience member. She's wondering, what happens if it's a parody of my work life and I'm creating very satired versions or exaggerated versions of my colleague, not revealing any workplace information, but it's just very exaggerated and it's really just for laughs. Really, any thoughts on that? I mean, if it's just a huge parody or trying to make it funnier than it seems.
Well, then the lines become blurred, right? A parody can be a parody, but the real question really is whether or not people looking at that video will be able to guess who you are referring to. Let's say your colleagues can watch whatever you have posted, right? And your parody is so obvious. It is so clear in your parody that you are mocking your boss or mocking this particular poor auntie from finance, right? Well, people are still going to get offended. So you put the legalistic, stuff aside, you're still going to offend people at the workplace, right? If you do a good job masking it, and the clues that you drop are very subtle, fair enough lah. So I think it's all a balancing act lah. You've got to sometimes take a step back from your own content and think about it from the perspective of a third person, right? Is it clear? Is it, obvious who I'm poking fun at? And if it's very clear, especially to an insider with all the relevant background information, then you've got to be a bit more sensitive lah. Paylin, what do you think?
I think you also have to have a good sense of how game or how what kind of a sense of humor your boss or colleagues have. I mean, if your boss is that kind of a person, who usually is quite chill and cool, then yeah, maybe. But if unlikely, very probably 3 generations away from you, then you may not want to try your luck. The second thing that we have seen is that you may think it's a joke, but that person who can be identified easily by colleagues and people from the industry could see it as something that will affect her reputation or his reputation, and then it could end up being defamatory. So I guess that's another thing to be concerned about, if you want to make a joke of someone or something, that from a legal point of view, you could end up doing something defamatory.
Thanks, Paylin. Well, the next part of this is Belle reshares or uses links, videos, and content from other creators or what she finds on the internet. Belle receives an instant message from a media outlet asking Belle for payment as Belle referred to their content. Well, really, from a legal perspective, are the media outlets justified in asking for payment, in exchange of using or resharing of their content?
I'm not sure what referred to means, but I think taking things from a very pragmatic point of view, what a lot of content creators do nowadays, and we can't blame them because we live in a very content-centric world, right? What a lot of content creators do right now is to repost content from other sources. Now, tricky, because whether or not you intentionally repost or you repost without thinking too much of it, it remains the fact that content online is copyrighted. We hear this word copyright being thrown around, but very few people know that you don't technically need to register for copyright in order for a copyright to take effect. Okay, so for example, if today I go online and I write a poem or I shoot a video or take a photo and I put it up online, instantly upon creation of that work, so for example, upon creation of the poem, upon the photo being taken, upon the video being taken, copyright latches onto that. Okay, and the work is protected by copyright law. And I, as the content creator, I own the copyright. So if somebody comes along online and reposts my content, shares it, republishes it, and doesn't get my permission for doing it, that person would have breached copyright laws. That person can be said to have infringed upon my copyright. Okay, and if I want to, I can technically take legal action against that person and ask for compensation. So if you interface this very, I know, boring and theoretical explanation onto the example that we were discussing earlier, I would say yes, right? If this Belle person really takes content from wherever she sees and then she reposts it without getting permission or without at least acknowledging the source, then she is setting herself up for a potential legal action.
Yeah, and that's another question that audience member had raised, right? I mean, can I post whatever I like as long as I just credit back to the source? Is crediting back the silver bullet to any sort of unhappiness by the content creator?
Not quite. Okay, not quite. Because the only foolproof way of preventing people from taking legal action against you is to get their permission. Crediting is not a silver bullet. It's not a watertight protection. But we see crediting sometimes as sort of like a halfway house approach, because it's very difficult sometimes, given the vastness of the internet, to determine who owns a particular piece of content. If you see a photo online and you really, really like it, right? You want to create a meme from it, for example, you don't know who originally took the photo, right? So the best you can do is to copyright in hope of the fact that whoever owns the photo, even after seeing the fact that we've used it, won't come after you, because you're not trying to pass off that piece of work as your own. Yeah. So I think the important thing to note is that not copyright. The important thing to note is that crediting doesn't defend you entirely against claims, but it's better than nothing.
Maybe I can add one more point about this. Sure. In terms of social media platforms like Facebook, for example, they actually have a share button. And so when people post on Facebook and they make their post public, whether it's a photo of words or a video format, when you make your content public, you are actually agreeing, according to Facebook contractual terms, that others can share using the share button. So when I click the share button, it will automatically show who the original post belong to. And therefore, so for example, if it is a media like, say, Straits Times or Channel News Asia that posted a story or a video, and I click share, and people can tell that it's from Channel News Asia, then they cannot come back and ask for payment, because by making their content public, they have already agreed that anyone out there can click a share button and share. Now, it is very different if you don't click share, but you download the photo into your own computer and then you post back the photo onto Facebook, because then you are not clicking the share button. Am I making sense? Then you are actually, you could be violating copyright rules, or you will not be protected by Facebook's user agreements that binds all users, if that makes sense.
No, it does. And thanks, Peilin. I think that's it's an interesting thing for everyone to note, actually, that when you post it online, and actually you're right, they have the reshare or the forward actually buttons, right? And so if someone does that, you just have to be prepared that you're willing to let it be reshared. And as you said, if you reshare it, hopefully the Facebook or Instagram or, whatever social media platform terms will cover that kind of situation.
Definitely cover if it's shared.
Okay.
Because basically when you click post, right, by making it public, you are already agreeing that others on the platform can click the share button and your content could be viewed by others that's outside of your friend circle. So that's why when you click post, Facebook will ask you, is this going to be public or viewed only by certain people, your friends, or you can even select your certain humans from your friend list, for example. Yeah.
All right, thank you. Let's move on to our next scenario. So Belle's efforts are paying off and she starts receiving attention from established brands. Belle made a sponsored post promoting a skincare product, stating that the product was perfect for attaining brighter and smoother skin. One of Belle's followers uses the product. The follower's skin becomes inflamed and medical treatment is needed. The follower demands to be compensated by Belle. Wei Li, is Belle liable to compensate the follower?
Quite unlikely, because she is only, so to speak, an advertiser or a promoter. She's not the manufacturer of the product, right? So it's unlikely she is open to any sort of significant legal risks here. But I think this example raises a collateral but equally important point. Depending on what kind of beauty or skincare products you're talking about, one may need a license or approval from HSA, the Health Sciences Authority, to actually promote these kind of products. It's okay if you are promoting a purely non-medicinal skincare product. Okay? But if there are components within the product that potentially qualify as being medicinal in nature, that kind of product is classified as a medicinal product, and we have very strict laws here requiring you to promote medicinal products only with approval from HSA. So if you interface that again with this example, and it turns out that whatever she is promoting is a medicinal product that needs to be regulated by HSA, she hasn't gotten the appropriate approval or license from HSA, and she goes ahead and makes all these claims, she could be in trouble because HSA can come after her, and she might then be liable for a criminal offense. Yeah. So with certain types of products, such as medicinal products, or such as even medical services, let's say I go for LASIK or I go for I don't know, liposuction, all these are classified as medical services. You want to run endorsements, you want to run advertorials, you want to run promotional posts on these kind of products, services, you got to be careful because you need to get cleared with the authorities.
Thanks, Whaley. That's good to know. I had no idea that you needed that kind of approval to, to promote these sort of products and services. Paylin, any thoughts? I mean, I think maybe not only just skincare, but obviously when influencers trying to push or promote a certain product, obviously certain things will be said, and maybe perhaps their followers, when they find out it's maybe not so true, may become very unhappy. So, Paylin, any tips on how to handle such situations?
I don't know. I mean, I've used so much weight loss products and services that were advertised by celebrities in the past 40 years, and I haven't sued any of these celebrities yet due to my unsuccessful attempt. So
Yep.
I was saying it's nothing new, as in we used to have celebrities or well-known personalities promoting products and services on TV, in the newspapers, and now it's just that they are on social media. So I would say I agree with what Willie said. If certain categories, then you may need special permission. But because of the word being a sponsored post, typically the established brands themselves would have certain guidelines.
Yep.
So especially food F&B companies, or food that's meant for children, for example, they're very strict guidelines, and they would require the influencers that they are paying to also post certain words to disclaim or to warn the public about the products or what to look out for. So it's very likely that Bell will be protected.
Thanks, Paylin. Disclaimers are important, as well as the fact that it's sponsored.
Yes, but not all disclaimers will protect you.
Okay,
generally,
that's important to note.
Yeah.
Okay, so don't just put a disclaimer and then just tell very exaggerated tales about the wonders of a particular product.
Yeah.
So, I mean, Paylin, adding on to this scenario, I mean, what happens if Belle receives bad comments? I mean, she starts on a deleting spree of everything. I mean, any thoughts on that?
I think if Belle wants to be an influencer, Belle has to expect bad comments to come once in a while. I think for many of our participants who join, they are probably not trying to be influencers themselves, but probably for their organizations, they have started to help manage the social media pages or posts, and we get that kind of questions often, especially from non-profit organizations type, right? That say, look, I was just trying to reach out to my volunteers and stakeholders, and that's why I started doing social media. But I get so many of these negative posts or people commenting nonsense that are so demoralizing. Can I delete these posts? Well, we do not recommend that you delete them entirely, because sometimes deleting them angers the person leaving a comment behind, and then that person may end up giving you a lot more comments that you have to chase to delete. The social media platforms actually have some of them have certain functions. For example, if you own a page on Facebook, you can actually set the setting of the particular comment such that only the person who posts the comment and his friends can see the comment. Now, what does that mean? That means, say, for example, you have 20,000 followers and Whaley posted a comment, right? And Whaley's comment is not very nice. So I'm going to set the setting such that that particular comment of Whaley's can only be viewed by Whaley and Whaley's friends. Now, why Whaley's friends? Because Whaley is going to call his best friend Serene and say, Serene, can you still see my comment? And Serene say, yeah, I can still see it. It's still there. Because as long as Serene is Whaley's friend, they can view the comment. Now, the remaining 18,900 people in on your page cannot see the comment anymore. So there are techniques or functions like that you can use on social media platforms to control the comments without deleting them in full. The other way is if you become a very, very successful influencer. If you look at one of the most successful one in Singapore is, of course, our Prime Minister, LHL. He has so many comments that nobody cares about those people who are leaving bad comments because you are unlikely to scroll through all these comments anyway. Because of the algorithm of the social media platforms, the more likes a comment receives, the more likely it will appear at the top of the list of the 1,000 comments as well. So another way out, instead of deleting comments, is to get all your friends and family to go and like a particular positive comment, and it will then rank a lot higher than the negative comments.
Thanks, Paylene. An audience member has a question. Yes, I think Whaley mentioned about medicinal products and services, but how about financial products? I mean, this particular audience member comments that there seems to be so many influencers who are pushing certain financial platforms or products. Is there any sort of regulation touching on that, Whaley?
A good question, yes. But the difference between financial products and medicinal products is that if you want to put up a post or you want to post content about financial products, you don't need approval from MAS, the Monetary Authority of Singapore. But what you need to do is to put a line in your content that says this post has not been approved by MAS, something like that. I can't remember the exact wording. Okay, there are also conditions that you must comply with if you are putting up content about financial products. For example, I can't remember again what the exact list is because this question, caught me off the cuff.
Yes.
But to the best of my recollection, some of the requirements that you must comply with would include your content must be balanced. So if you are, let's say, promoting an insurance policy, on top of talking about what the potential returns are, you must also mention what some of the risks are. As with all financial products, there will be ups and there would be possible downs, right? You can't have content that is hidden in very, very tiny fonts. Okay, I think that's one other requirement. You cannot use very exaggerated words. You cannot use very hyperbolic words. Okay, so you cannot mislead. You've got to be accurate. You've got to be honest. And I think all these requirements are there to prevent your content from potentially misleading members of society who are not that sophisticated as an investor. And we know, of course, if you induce or you misrepresent and then somebody who's not sophisticated invests in a particular product, the losses can be significant. You can wipe out somebody's life savings with that. So if you are, and I know a lot of financial advisors now, they take to social media to promote their business, to promote certain products that they think might be useful, or they may do this promotion with the best of intentions, right? But it doesn't change the fact that you have to check with the MAS requirements on what you need to comply with, and then make sure you don't run afoul of that. Now, the reality of it is this: if nobody complains about you, okay, then fine lah. You may continue leading your life without any running into any sort of troubles lah. But I always tell people and I always tell clients, right? Nothing happens until something happens. It may sound very stupid, but it makes a lot of sense. Once somebody files a complaint against you, I mean, it could be somebody who doesn't like your face. It could be somebody who doesn't like the way you talk on your YouTube video. It could be a competitor who's out to do you in. Right? Once somebody launches a complaint with the relevant authorities and they start looking into you, then GG lah. You're going to run into difficulties. Yeah. I hope that answers the question on financial products.
Yes, yes, it does. I mean, and also taking note I think a good point you said. I mean, if someone's not happy with you, and given that you're an influencer and everything you have is out there in the public, once someone makes a complaint, everybody's going to dig into all your posts and something will come out, even you think it's innocent back then. Pelin, do you have anything to add?
No, not for financial. But I was just looking through the questions and yeah, there are quite a lot of interesting questions on Pigeonhole.
So the next part I want to know is that Belle receives a PR package from Furry Coats. Belle uses the codes but does not credit or promote Furry Coats. Furry Coats emails Belle asking her to pay them for the products as she did not credit or promote their brand. Pelin, is there a difference between a PR package and a sponsored post?
Yes, there is. Typically when we work with clients and they tell us they want to engage certain influencers to do sponsored posts, and as the agency involved, we will write to the influencers and we will make it very clear that we would like to pay for sponsored posts. Let us know how much and what will we get in return. Then payment is made either the client directly to the influencer or through an agency like where I work. Now, I think the term that we use is usually called media drops. MEDIADROP, media drop. That means we drop off a media pack.
Yeah.
And that is something that we used to do more than 20 years ago when I first joined the industry. We used to do that with the Straits Times, with Channel News Asia, with the journalists, for example, food editors, right? So if a client launches a new range of potato chips, we could put it into a package and we would drop it off to the food editors of the various magazines and newspapers and hope that they will, number one, eat my potato chip, number two, like it enough, number three, write about it. Now, after they finish your potato chip, then they say, hey, Eileen, actually the potato chip is awful. I better don't write lah, because if I write, I'm not going to write anything nice, right? Then of course the answer is, yeah, please don't write, okay? Then you have to explain to your client, hey, your potato chip 不好吃, not nice to eat, right? Now, but what if I eat your potato chip and I want to write about it and tell people better don't buy? It's very, very not nice to eat, right? I totally didn't enjoy the taste at all. Now, I will leave Wei Li to explain more about defamation, but generally, yes, by saying that the potato chip is not nice is defamatory, but the editor has a very good defense, and that is possibly fair comment, or he's telling the truth. It's really too spicy, for example. Then he could be protected from the defamation suit. Now, this PR package with influencers thing is a little bit more tricky. I had a client who wanted to send something to an influencer, and we actually wrote to the influencer beforehand that, hey, we're going to send you this product, and the product is I will not name exactly what, but you can imagine that it is a very expensive product. Imagine it to be in the thousands of dollars type of product, okay? And it's the kind of product where once you open up the packaging and you start using it, it's inappropriate for you to return it to me. That means it's not a vacuum cleaner that you can return me, okay? Yeah. And we wrote via email first, but the clients would like to request that, if you are agreeable to receive this product, you will do a post about the product if you like it, right? And the influencer replied to say, yes, I'm willing to do a post, and please send me the product. Now, technically speaking, it is sponsored, as in the product was sponsored, but there was no cost involved, as in you don't pay cash to the influencer. And subsequently, the influencer just went MIA. Like, you call also, there don't pick up, email also don't reply, and there was just a lot of unhappiness, obviously, because the client felt like, hey, you took my product, then you never do anything about it, right? So can you return me the product now? But I can't even reach the influencer. So it's a very tricky situation. And in there, we had to just write it off literally, because we also felt you can't turn up in people's house demanding for something that you really gave away. So it's a risk that the clients have to be prepared to make. However, I do think that if there was no prior agreement that Bell would definitely credit or promote the product, then it is industry practice that Bell receives the package and it's up to her whether she wants to post or not. So I
Thanks,
will use
Pei-
the term industry practice.
Thanks, Pei Lin. So industry practice that, well, sunk cost, right? I mean, you
Yes.
chose to give away these, as you said, media draws or PR packages or things like that, and that's part of the cost of doing business. Really not sure if you have any different views whether Bell's obliged to pay back for quotes just because she takes the product but never credits them for it.
No, my views are very much aligned with Pei Lin's. She made very good points. I think she mentioned this very important word. It's a very simple word, but it's very important. It's called agreement. It depends on what the agreement was between parties. I don't like to use the word contract because whenever we use the word contract, people will think, oh, you need to sign something, you need to draft something, lawyers need to step in. But unbeknownst to most people, a simple agreement, a verbal agreement amounts to a contract, right? If I say I'm going to give you X, you're going to give me Y in return, that's a contract. We don't have to sign anything. It's a legally enforceable contract. So when we advise brands, businesses, marketing agencies, we always tell them, look, if you want to send something to an influencer or a KOL, and you want to make sure that they post something good about it, the agreement must be worded carefully, right? Of course, if you send things to people, you do a media drop without asking them whether or not they want it in the first place, then you can't expect them to do anything about it because they've not said, I want it, ma. But if you reach out to them and say, hey, Bell, I am going to send you a vacuum cleaner free of charge. In return, we would like you to post 2 Instagram stories, 1 reel and 1 permanent post about it, right? Then you see an agreement forms, right? Because I'm giving her something, the vacuum cleaner, she's going to give me the posts. Now, that's not enough, okay? The decent brands will say, okay, I give it to you, you post something. The better brands who are more sophisticated will say, you post something that's positive, right? Or you take it even further, the better brands will give you a list of talking points, keywords. You need to include these keywords in your post. And these keywords are usually very positive keywords, okay? So that's how brands actually control for the returns that they'll be getting on their media packages or their media drops, right? Of course, from the point of view of an influencer, you cannot be Cao Kuan lah. Cao Kuan meaning you cannot try to play punk lah, right? If you have already entered into an agreement, be it verbal, be it over Telegram, WhatsApp, or email, which says that, look, if you give this thing to me, I will do certain things in return. For example, put up certain content or put up certain posts. You have to do it because if you don't do it, they are going to come after you for what we call breach of contract. Now, they may not necessarily say, hey, I want you to pay me the value of the vacuum cleaner, right? But they may come after you and say, I want to hold you to your word. Please put up the posts. If not, and if they are, renegade enough, they may take legal action against you. You never know, right? So, yeah, agreement is important. Be careful of what you are agreeing to and make sure that if you don't like certain things, don't agree to it. For example, if you are an influencer, somebody gives you, let's say, a packet of potato chips, okay, using Pei Lin's example, okay? And then the potato chip maker says, in return for this potato chip hamper, I want you to put up 3 Instagram reels, 4 permanent Instagram posts and 5 Instagram stories, and then pin the Instagram stories to your favorites for 1 month. As the influencer, you give me 1 hamper of potato chips. You want to extract so much value from me. If you don't like it, then tell them no, either I'm not going to do it or I can do it, but I will only give you 1 Instagram post. Negotiate before you lock in the agreement, because once you've locked it in, you cannot back out of it without legal risks.
Thanks, Raylin. Good reminder that you can negotiate, you can discuss it. Don't just keep quiet and just agree simply without thinking it through. An audience member asked a question about comparison videos, right? What happens if they do a comparison video between more than 2 products and say, hey, product A is better than product B? That's their own personal view. But would they get into any trouble by the companies if they were to say such a thing? Willie, what's your thoughts?
Depends on how you word it. We see a lot of comparison videos, right? There are ways of expressing your thoughts without running the risk of being taken to court for defamation. So instead of saying this potato chip sucks, it's awful, I can send the same message by rephrasing and saying, I personally don't quite like the taste. I would never buy it again. Right. The first set of comments, objective statements of fact, right? It sucks, it's awful. The second set of comments, I don't like it. Subjective. It's personal to me. I will not buy it again. Nobody can fault you for not wanting to buy it again. Nobody can fault you for not liking something, right? So it's actually very much, I mean, I'll leave Paylin to talk to you about the wordplay aspects of, effective PR, but watching what you say and how you say it is very important in managing the risks that you may encounter as an influencer or when you create content.
Thanks, Willie. Paylin, anything to add?
I agree with what Willie said. I mean, his excellent advice is, I don't think I can top it with more advice, except to say that, maybe if you are really lost, you have no idea how to phrase certain things, like Willie said, there are a lot of comparison posts and essays or articles already written out there. Go and learn from other people and write in that way that, something could be defamatory, but you could have a good defense for it, right? Either because it's really the truth, like I say, if it's really very spicy, and then you probably can say that it is very spicy, versus a fair comment. So making sure that you are saying that this is, in my own opinion, I do not like it because of my own taste. So things like that, I would say possibly, yeah.
Thanks, Paylin. Let's go on to the next scenario, where Bell becomes successful. Coincidentally, this scenario hits the nail on the head for another audience member's question. So Bell's fan alerts her that someone is impersonating Bell and tries to sell health products. Really, from a legal perspective, I mean, what can Bell do, to stop someone from impersonating her and pushing out things she don't quite agree with?
So this area of law is very underdeveloped here in Singapore. If you talk about impersonating someone, how? Have I hacked into that person's, for example, social media account and taken over the media account? If I have, then obviously this is criminal offense. She can go to the police for it, although the police may or may not do something about this. All right. Another way to impersonate somebody is to set up a competing profile and then use that person's photos, pretend to be that person. All right. That's usually what we call identity theft. We don't have very developed laws to target or counter identity theft here in Singapore. At the risk of sounding very, very legalistic, there is this doctrine in intellectual property law called passing off. Passing off happens when I try to pass off my products as yours. For example, I go to a pasar malam and I start selling LV bags. Okay, I zeng a bit the logo, but on the whole, it looks like an LV bag. LV can come after me for what we call passing off. But the thing about passing off as a legal doctrine is that to date, it has been applied very extensively only to goods, products. We haven't actually yet, I mean, to the best of my knowledge, seen a legal case in Singapore where person X goes after person Y under this doctrine of passing off for passing themselves off in terms of an image or in terms of a personality, right? So we're not sure whether or not this legal doctrine of passing off works. Now, let's skip all that legal mumbo jumbo. If I were Bell, I mean, and I'm not happy about somebody pretending to be me, I can simply just reach out to that person and say, hey, can you stop doing it? And a lot of social media platforms now actually have this option for you to report what we call an impersonator, right? You can report a profile for impersonation, you can report a profile for trying to pass off as somebody or something they are not. Of course, you may have to give them further information to prove that you are the real you. That fake profile is not the real you. But there are these various non-legal, so to speak, options that you can explore if somebody is trying to pretend to be you and make a quick buck of it. Yeah.
Thanks, Willie. Palin, any tips to Belle? I mean, handling such a situation when someone's pretending to be her?
Number one, she should be posting about it. I mean, she should post to warn her fans that this person is impersonating me and it's not me. And she's trying to sell some health products. It's not me. Do not buy. Do not believe. Number two, Whaley is absolutely right. Social media platforms have a complaint button that you can complain and say somebody's impersonating you. But they usually work better if a lot of people complain. So what Belle should do when she posts her post to say someone is impersonating me is to tell all her fans and friends to go and report this person. Because if Facebook or Instagram receives 2,000 complaints against a profile, they are more likely to act on cancelling the profile or suspending the profile as opposed to receiving only one complaint. So the more people complain, the more likely they will act on it very quickly. And then, of course, make a police report, which then, because it's health products and not just any other products, earlier we talked about possibly requirements from Health Promotion Board, etc. There may be regulations that the person is also breaking because it's a health product.
Thanks, Palin. Right, so taking this scenario a step further, right? So now you have Belle, who discovers Elle, who posts very similar content to Belle. Okay, so Elle posts skincare reviews with very similar branding styles, writing styles to Belle, even using the same slogan, "Blessed, not stressed," for her morning vlog. Elle also once posted a photograph of Belle's room from Belle's page with minimal alteration. So in this case, it's not someone impersonating you, but someone who's really very much copying your style and what you're doing. So Whaley, is Elle liable for copyright infringement of Belle's content?
Why you all must use such
Names.
villain names to test our pronunciation? Now I feel like I have to enunciate very clearly to be understood. Okay, so I think this takes us back to what we spoke earlier, right, about copyright. So this is a great example, a slogan, "Blessed, not stressed." Is that protected by copyright? One could run an arguable case to say it is, because it is a creation, it is an expression of ideas, right? Much like a poem is, or much like a photograph is, right? It is a creation that is expressed in a tangible form. So if L, starting with an E, rips the slogan of Lock, Stock, Barrel and puts it up on her own platforms, I would say Belle might have a potential case against L. Am I being very clear here?
Yes.
For copyright infringement. Now the photo. Now, if the photograph was taken by Belle, she owns the copyright to it, right? Because she's the creator of the photo. If Elle takes that exact same photo without any modifications and puts it up on her platform, then yes, there is clear-cut copyright infringement. But I think a very interesting question which I get asked all the time is, if I take a photo, I zeng it a bit, meaning I modify it a bit, right? I put it into Photoshop, I adjust the saturation, I remove a flower pot from the table, and I use the color swap function to change the color of the wall. Am I liable for copyright infringement? Because now whatever I'm posting is different from the original photo. Now, there is no clear-cut answer to this. I know it disconcerts a lot of people to hear that the law doesn't give clear-cut answers, but the reality of the matter is the law is always very gray, right? So it very much depends on how much modifications you make and whether or not, if an objective third person looks at both photos, they will be able to immediately tell that the modified photo was a rip-off of the original photo. Okay, so it's a very fact-based, very subjective sort of analysis. So it depends. I mean, depending on how extensive her modifications are, Elle could potentially still end up in trouble over copyright infringement.
Thanks, Willie. Palin, any thoughts? I mean, I guess maybe Elle might be thinking, oh, Belle is so popular. Let me just follow, and hopefully I will achieve similar heights of popularity.
I guess we often do see some influencers doing this, calling out how someone else is either copying them or impersonating them or having very similar style. And then because in this case, Belle has already become successful,
Yes.
assuming that it means that she has a very strong following, she could post about it. And her followers will then be sort of out there to be the judge of it. That means her post could be, hey, this person posts very similar stuff to me. What do you all think? So you're not really judging. You're allowing your followers and fans to make the decision. And they could probably come out to defend Belle, to attack Elle on behalf of Belle. And then Elle may find herself in not such a good situation when everyone's sort of ganging up to say, hey, why you go and copy people? Be more original lah. Yeah.
Thanks, Pelin. This brings us to our Q&A session. So a gentle reminder that you can submit your questions through the Pigeonhole Live. So one question, grouping together a few questions, is what happens if you're just a stranger, okay, just somebody walking on the street, and unfortunately, an influencer takes pictures of you in the most unflattering light and decides to share on social media and write about you in a very unflattering light. Is there any way to stop her? Because you're out in public, and here you are being picked on by the influencer. Wei Lin, any thoughts on that?
Oh, what kind of evil people or influencers does that? No, okay, maybe let's just, it's a good question, but let's frame it in a more realistic light, right? I don't know whether you guys have heard of this guy who made news recently. He sits on MRT trains and he sketches people who are seated across of him. And then he puts it up on his Instagram, the sketch. I mean, the sketches are quite nice. So a very interesting legal question that surrounds this, which I got at one of the recent talks that I gave, is, hey, is the artist liable for any sort of legal offense or crime? How can you just sketch somebody and then you put it up online? Very much depends on the quality of the artist's work, right? If whoever is sketching looks nothing like the real person, then I'll say he gets away scot-free, right? But if he's a very good artist and whatever he's drawing is a very good reflection or manifestation of the actual person, can the person who's being featured go after the artist and say, hey, I didn't give you permission, to feature me? Unfortunately, here in Singapore, we don't recognize this concept of image rights. I don't want the right to my own images, right? Sad but true. Some other countries have that, okay? So you fall back on copyright. Can the person who's being sketched go to the artist and say, hey, you've infringed my copyright? Again, the answer is no, because we know that the copyright owner is the person who creates the work. In this case, it's the artist, right, who created the drawing. He owns the copyright. So how? What do we have to go after somebody if that somebody puts up, let's say, a photo of me that I don't like, right? Depends on what accompanies the photo. Okay, if the photo is put up purely as a post without any sort of negative comments, then I would say you probably don't have that much on which to go after the person. But if the photo is accompanied by very negative comments, or this person is really ugly, look at how unglam this person is, right? Or if the photo is accompanied by information that allows whoever is looking at the photo to identify the subject of the photo, then I would say whoever is being featured, if upset, can actually go after the poster for first doxing, okay, and second, possibly even online harassment or cyberbullying. Yeah.
Thanks, Pelin. Anything to add?
Last time, every time there's a new rule when it comes to smoking or cigarettes tax, right? Then the newspapers will take a photo of a group of smokers at a dustbin outside a building, and then they'll post it. And people go, hey, I don't give permission for my photo to be taken. Now I'm in national newspapers with my photo there, and I'm smoking. Like, well, how can like that? Well, so I think the law is like Wei Li said, is that if you choose to be in the public space, then it's taken that you are giving people permission to take your photo. The good news, not good news. But now I guess wearing a mask is very common. Putting on a cap is very common. If you really do not want to be photographed or have your image taken, then please make sure that you either don't go out or your face is blocked to some extent. Otherwise, the legal protections, Wei have gone through them already.
Thanks, Peilin. Another question from the audience member is a particular person. She wears particular items from a certain brand. She looks fantastic because the company then takes her photos without her permission and posts it on their website. She feels very uncomfortable because she didn't give any approval. She posted on her own website. How can a company just take photos of herself wearing their products and just put it on their own website? Wei, what are your thoughts on that?
This goes back again to copyright. Actually, it also goes back to what Peilin said earlier, right? Did she put it up on Facebook or Instagram? Because if she did, then she would have unknowingly entered into a contract with Facebook or Instagram. And this contract technically says that she has given not only Facebook or Instagram a license to repost the photos, she has given whoever it is who's using Facebook or Instagram a similar license to share the photo, right? But of course, that kind of protection stands only if the reposter shares it. Like what Peilin said earlier, and I repeat it at the risk of sounding like a broken record. If the brand, downloads it and then, reproduces the photo on, let's say, their website, right, without using the direct share function, or reposts the photo in a new Instagram post without using the direct share photos, then the brand would be technically infringing upon the copyright of the person who took the photo, the person who wore the dress. Because remember, the photographer owns the copyright to the photo.
And maybe even Facebook, I'm not sure whether the contract or the rules or the law has changed. But I recall at one stage there was a question of when you post your video on YouTube, for example, you are literally giving away the rights of your video to YouTube, and the rights now belong to YouTube. Similarly, if you post a photo on Facebook, that photo becomes owned by Facebook, and you may not even have the original right left to go and sue people for it. I'm not sure if that has changed though. I've not followed, so Wei can comment if he knows.
I don't think it has changed. And I think the simple reason for Facebook wanting to keep the right to publish the photo is that you are putting it up on Facebook. If you don't give Facebook, the platform, the right to use it, the irony is that you can then go to Facebook and say that, hey, you have my content on your platform, I'm going to sue you. Makes no sense, man. Right. So when you put something up on Facebook or Instagram or any other social media platform for that matter, you are technically, like I said, whether or not look, none of us read terms and conditions, right? When we sign up for an Instagram account, wow, we just put in the username, put in the email, and then we click yes, I agree to everything, right? But nestled within that kick-ass set of terms and conditions would be clauses saying that whenever you post something, Facebook has the license to use it or to reproduce it or to host the content. Yeah.
Thanks, Wei. Another question, I guess in general, just touches on the topic of how responsible is an influencer for the action of their followers. So just perhaps following up on, let's say he were to say, hey, even you try to anonymize it and say, hey, I have a very unpleasant situation with a particular person, etc. And then the followers, of course, goes up in arms, finds out who it is, and then goes after that person. To what extent would the influencer be actually responsible for the action of followers? Wei, any thoughts on that?
I mean, it depends on how much of an accomplice you are. If you go and fan the fire and you go and instigate in very clear language, right? Hey, let's hunt down this person, find out where he works, find out where he lives, put up the information, make sure he loses his job. If you, in very obvious language, instigate this kind of mob behavior, and not uncommon, right? We've seen this, right, happen from time to time, then you would be responsible. But if you put up a post and say, hey, I've had a bad encounter with this person, and you leave it as that, and then your followers, on their own volition, go after that person, then I think legally you should be quite safe. But this leads us, I think, to the larger phenomena of what we call cancel culture. Right? Cancel culture, I mean, some people say cancel culture is very it's almost like boycotting, right? You don't like a product, you boycott it, you don't buy it. But cancel culture is different from boycotting because cancel culture has this element of instigation that boycotting doesn't. I can personally boycott something because I don't like the brand. I don't believe in its values. But cancel culture is different because with social media now, I can say, hey, I don't like it. I'm going to tell the whole world not to like it. I'm going to instigate everybody to boycott this person, boycott this brand, boycott this business. That's when we start running into legal risks and difficulties, because if it can be shown that you had an active part to play in toppling or in harassing or in cyberbullying a certain person or saying negative things about, let's say, a particular business, then I think you can be hauled to court for it. Yeah.
Thanks. Next question is, we talked earlier about caricatures about the workplace, but what happens if this caricature or this figment of the influencer's imagination is really her creative endeavor, yet someone out of the blue comes to her and say, hey, you're making fun of me. Then the influencer's response is, I don't even know you, so I didn't even base anything off you. Perhaps this is more a question for Pei-Lin. How do you handle such things where you are writing, perhaps, or creating content and someone accuses you of basically basing it off them?
What should you do? No, I guess the first question is, did you really base it off that person? That means, was that someone you met in MRTV and you were really drawing her? Or actually you were drawing your mother and, and somebody comes along and said, why are you drawing me? If it's the second case, then I would say, please be honest and post and say, look, somebody approached me, talked about this photo I posted. I would like to just share with everyone now that actually I was looking at my mother when I was drawing it. And whoever wrote to me, you just happen to look like my mom, or maybe you're thinking too much because I didn't think that my caricature looks anything like you. So don't get offended, right? But if you were really targeting, I mean, you were looking at this person in public and you drew, and that person then text you and DM you and say, hey, you're drawing me lah, I don't look like that lah. I mean, look at me, I'm so slim, you draw me until so fat, right? How can you do that? Then are you in the wrong? Well, technically speaking, it would, if that person is really not recognizable, then nobody will recognize that person. Then actually you are not doing anything wrong. But if it's very recognizable, then you could be possibly be defaming that person. But then again, you may have the defense of either fair comment or the truth, i.e. you're really very fat, so then never seen the mirror, this is what you actually look like, then no choice. Yeah, generally speaking, I would say if very popular influencers, they usually would either be a lot more careful about their posts, try not to offend strangers that way, or because it could result in their followers disagreeing with their jokes or comments about certain characters, especially of strangers. Yeah.
Thanks, Pei-Lin. Really not sure you have anything to add to that?
No, I think Pei-Lin summed it up very well. I think it's not always about being legalistic all the time. And I know it's ironic I'm saying it because I'm a lawyer, right? But in today's day and age, sometimes being overly legalistic can actually get you into more trouble. Right. I mean, if you are a brand and then somebody says something that's not so flattering about you, and then you say, oh, I'm going to sue you, right? People are going to hate you more because people are going to see you as an oppressor. So a lot of, trying to manage the dynamics on the internet, on the social media is as much, I mean, you need to know your legal rights, but you cannot pull it out all the time. You've got to manage it from a very astute PR or publicity kind of perspective. I think there's a question there that I see that I think both Pei-Lin and I can weigh in quite a bit on. And the question is this: are there any legal protection for companies when influencers get into trouble or get cancelled? And I think this one's coming from, let's say, somebody who's running a brand. Right? So I suppose the question is, look, if I sign on an influencer to promote my products, and then this influencer gets into very bad publicity, I want to protect my brand. What can I do? Pei-Lin, what do you think? It happens all the time, right? You
All the
see how
time.
brands drop, all the time, how brands are quick to drop influencers like a hot potato the moment the influencer or the KOL gets into bad press. So how would you suggest brands handle that, Paylin? What do you think?
It really depends. You look at Joseph Schooling in the most recent case. I think it was Hugo Boss that came out first and say that they will sort of stand by Joseph Schooling, and that I can't remember the exact words, but they said something along the lines of how they appreciate that Joseph is owning his wrong, and they will stand by him lah. Whether it is when winning an Olympic gold medal or when he's going through troubled times like that. I'm not going to comment about Joseph, whether he did right or wrong, but Hugo Boss received a lot of positive comments from their fans and the community, who were very impressed by the way they handled it. So as a brand, as a company, instead of asking how can I be protected as a company if my influencer that I selected is cancelled, they should turn it around and look at it as whether, I wouldn't use the word opportunist or whatsoever, but more of what is the right way to handle, what does your brand stand for, and what do your customers hope to see from a brand like yours. Do they want you to take a very strong stand and say, I want nothing more to do with this influencer? Or do they want you to be maybe a brand that's either bigger hearted or be able to stand by an influencer who has done wrong? So a lot depends also on the wrong, right? And whether the influencer, for example, has come forward to own the wrong, or is still trying to deny or finding excuses for their wrong. So there isn't a standard response that I can give. It really depends on the situation.
Thanks, Paylin. Another question was, do social media influencers need to get lawyers to draft anything?
I have answered this. Because Wei Li is the lawyer, I will say, yes, of course. It's very important to give work to lawyers and always pay your lawyers well.
Thank you. Thanks a lot for the vote of confidence, but I'm going to do myself a disservice by saying not necessarily.
Why you like that?
I got to be honest with people. That's how you get their love, man.
Google Wei Li and email him.
I mean, ideally, it depends. Look, let me be very honest. Okay, it depends on the value of the work that you are getting into. If it's going to be a high value working relationship, meaning you are, as an influencer, you are giving out, let's say, content or posts that are worth tens of thousands of dollars, 20, 30,000. And sometimes content is not easy to create. There are influencers and there are influencers. There are, of course, influencers who will say, okay, I'm going to create content using my iPhone, right? But there are also influencers who run a team. And when they create content, they have a professional team producing the video, doing the storyboarding, doing the shoot, doing the lighting, doing the post-production editing. Hey, you need to pay people to run such a shop, right? And if you are getting yourself into a project that requires a lot of investment, then I would say it makes sense to get a professional to do up a proper agreement, right? Of course, if you are not at that level or you are working on a smaller project, you may not need a lawyer, but I go back to what I said earlier, you better at the very least look at the terms of what you have agreed on, the emails you have exchanged, the text messages you have sent, be very clear what they're going to give you and be very clear what you're obliged to give them. If you're committing yourself to 3 posts, you better give 3 posts. If you are committing yourself to 3 posts by a particular timeline, you better give the 3 posts by that timeline. If you fall short of any of these requirements that are put down in black and white, be it in an email or in a WhatsApp message, then you are setting yourself up for trouble, right? So you may not necessarily need a lawyer. I think that's the moral of the story, but at the very least, be very clear in writing about what the transaction entails and what each party is supposed to do or perform. Yeah. Paylin grinning away.
Yes, but if you do need a lawyer, please contact Wei Li. You can easily find his contact details online.
Thank you for the plug, Paylin.
So another topic is on taxes. I think we earlier mentioned about your media job, your PR boxes, etc. These sort of things, do you need to declare them and pay taxes as an influencer or content creator?
Yes, IRAS actually has very clear rules about that. And if in doubt, it's the easiest thing to do in Singapore is to pay tax. Let's put it this way. You should have questions about that. But yes, go to IRAS's website. It's stated very clearly under what circumstance you need to pay tax, including sponsored products. It could be taxable. How do you pay the tax? You declare it in your IRAS declaration, your tax declaration every year. You can declare how much you make. Yeah, if you are individual, but if you are incorporated business, then obviously your business will be the one paying tax.
One associated and practical tip. What Paylin said is absolutely correct. Even if you receive it, you didn't ask for it, you received it. Okay, it's taxable. So the problem is not so much deciding what's taxable. The problem with a lot of influencers is come tax declaration season, not recalling what they've gotten. So you've got to keep records of what you receive. Not only do you need to remember what you've received, you have to know the market or the retail value of what you've received. So whenever somebody gives you something, you should, as a matter of best practice, either go online and look for the prevailing selling price, or if it's a new product that has yet to hit the market, right, ask the supplier or the brand or the manufacturer what the market price of this item is. I know a lot of influencers focus a lot on the creative, right? They think that all these nitty-gritty administrative work is either beneath them or a hassle to do. But again, like I said, nothing happens until something happens, right? What if one fine day you make it big and IRAS decides to run an audit on you? Or what if one day you have, let's say, a very lavish wedding that's sponsored by brands, products, left, right, center. It gets reported in the news, and then IRAS decides to run an audit on you. The irony of being in the influencer business is that your legal risks become a lot more pronounced the more famous you become. It's the price of fame. Okay, so I think a good tip that I will have for influencers, be it whether or not you are starting out or be it whether or not you are already established and successful, is that you need to focus on the administrative part of your business as much as you focus on the creative. Because if you don't, then when you run in the hot soup, you're going to have a lot of trouble justifying what's what and what's not. Yeah. So keep receipts, keep records, ask for what the price is, and then have some sort of system going on at least. Yeah.
Adding on to this, another audience member asked, what happens if I receive, I receive the items, I don't want it, and I just give it away as giveaways or prizes? Do you need to pay tax on such items?
Paylin, your views? I mean, I have an answer, but what do you think, Paylin?
What is it? Prizes?
Yeah, so you receive items from a brand, but instead of keeping it, you decide to give it away as giveaways to your followers.
Oh, receiving it is revenue in inverted commas. Giving it away becomes an expense. So net is zero technically.
Technically, yeah. But you see, I think tricky also. When you receive it and you don't really want it, and you create a giveaway, in creating the giveaway, you are making public the fact that you've received it, right? So it depends on how closely IRAS is watching you. I kid you not, let me share a real story with you. We've seen the kind of records that IRAS keeps on influencers, especially if they are really bent on making sure that this influencer declares tax properly, and the records are massive. They literally have records of every post that the influencer puts up, the kind of products or services featured in those posts, and the corresponding market value, right? So you've got to remember, if you don't want to declare tax on something and you don't truly want it, giving it away by way of a publicized post might not exactly be the smartest thing to do from a practical point of view. You can return it, right? And say, I don't want it. Or you can just, keep it and give it away secretly to a friend or not use it, but don't make a big hoo-ha out of it. Don't post it. Then nobody would know that you've gotten it, right? I'm not teaching you how to evade tax. Don't get me wrong. Okay? I'm just telling you how to be smart about certain things.
I think the end point is keep records, and the IRAS is paying attention. And unfortunately, as influencers, like it or not, you are facing a lot more public scrutiny. So don't hide it. The other question for Whaley is, you mentioned about, well, we may not need lawyers to review contracts. So what happens if it's WhatsApp messages, and not like a contract where you sign with signatures? So if it's WhatsApp messages, would it be legally binding?
I think both Paylin and I can agree that those would be legally binding, right? As long as you have in very clear terms what the duties, obligations of both sides are, and it's reduced to some sort of, written format, that's legally binding. I mean, even a verbal contract or a verbal agreement is legally binding. So if I were to tell Paylin over the phone later, hey, Paylin, I am going to engage your PR services, and Paylin says, oh, okay lah, I will charge you 50,000 for this PR retainer package, right? Nothing gets signed. It's purely a contract over the phone. It's purely an agreement that was reached over the phone. If I don't pay Paylin, or if Paylin doesn't deliver at the end of the day, we can still take each other to court. Yeah. So long story short, WhatsApp agreements are legally binding and they can be legally enforced. Yeah.
Agree fully.
Thanks. This will be the last question, being mindful of time. What are the common legal disputes that you see between influencers and companies that sponsor them?
Maybe we don't talk about the legal disputes first. What are some of the practical disputes, Paylin, you see? I mean, you work so often with KOLs, brands, right? How are some ways they disagree with each other? What do you think?
I think it's very similar to media also. One of the key things is the way the media or the influencer describe the product and services. So like I said earlier, we've invited media to try out products, to try out restaurants, F&B outlets, or come and experience my hotel, right, and do a review for me. And I read the review and I think, hey, very cool. I say that it's very nice, I mean, there are some like, oh, when I entered, I at first thought that it was like, I was expecting this, but to my surprise, it was so beautiful and nice. The clients or the companies could get very offended with well, why did you say that she expected the lower standard? Then, for us, it's like, hey, but you go read the behind, it says that she was very surprised and that it was very beautiful and very nice. But the company could feel, oh, but people will just read the first sentence and they won't read the rest of the article. Then how? Can you ask her to delete that part? Very challenging, because especially if it's not sponsored as in direct payment made. Maybe it's just by sponsoring the staycation, for example. So she really finished the staycation, right? But the agreement is I could write it any way I wanted, and this is my style as an influencer. But for the hotel or the company, they'll be like, hey, but how can she write like that? Say that she expected something lousy, right? So it's always and then for us as agency or consultants, we try to bridge that gap and explain, or we try to direct their attention to, hey, look at the comments. Everyone has very good things to say. Or do you see your bookings going up? Then it's effective, right? So stop complaining. So there are sometimes ways to bridge it. These are very likely the more common issues faced.
Thanks, Paylin. Really, how about you?
Content, I would agree with Paylin. The mismatch of expectations is one thing. I think the more common disputes besides mismatch of expectations would be delivery of obligations. Sometimes brands don't pay, right? They're late on payment and the influencer gets very angry because they'll say, hey, I'm running a business as well, right? Sometimes, on the other hand, brands pay, but then the influencers don't deliver, right? Instead of giving, let's say, 5 posts, they give only 3. Or instead of giving 3 posts by a particular timeline, they do only 2, thinking that, oh, I can do the last one after this timeline. But unbeknownst to them, the brands have a very strict marketing timeline to follow, what kind of content gets rolled out when, right? And this all boils down to knowing what you need to do by when. And again, like at the risk of sounding like a broken record, it all comes down to nailing down the terms of your working relationship. Right? The other common dispute, and I think this we can end off with this point because time is running short, relates to use of content, right? Let's say I enter into a working relationship. I'm an influencer, I'm Belle, and I enter into a working relationship with a brand, okay? And I produce content. Can the brand, 2 years down the road, dig up this old content and then repost it again? Right or not? If I'm Belle, I may say, hey, our agreement doesn't say anything about you being able to use the content 2 years down the road. But sometimes brands are not knowing their exact legal or contractual rights may say, I mean, I already paid you 5,000, 10,000 for this campaign, right? Whatever that you produce under it, surely I can use again and again down the road, right? But things are not as simple as they seem, because these issues, they involve a lot of intellectual property law, a lot of contract law. So again, agreement is very important. Yeah. And I go back to what I said earlier. If it's a small value kind of like working relationship, maybe you don't need a lawyer, you don't need a proper agreement. But if it's, you know, substantial, the value, then you may want to get something drafted by a professional or get something looked through by a professional. Yeah.
Thanks, really. No, important point when it comes to, I think, this sort of agreements is to consider the time frame, whether the brand can actually keep using your image and your post forever and ever. I think that's something important which maybe doesn't instinctively comes to anyone's mind when they're first approached by brands.
Me as the influencer, my instinctive reaction would be, it's my content, ma. How can you keep using it? You pay me one time 5,000, you can use for eternity, man. It cannot be what, right? But from the brand's point of view, wow, I paid you already, what? Shouldn't this belong to me? Yeah. So again, like Paylin said, mismatch of expectations.
Celebrity, same thing lah. When you use a celebrity as your ambassador, there is a period of time you can use it for. And for us, we call it loading, in the industry, LOADING. How long is the loading for? I think we have 5 more minutes, right? There's some questions that I would like to just very quickly run through.
Sure.
And Wei Li can jump in because I'm going through the questions and they're very interesting. When an individual uses short clips that belongs to another YouTube channel, what are the potential issues? How to do it legally? There's no way to do it legally. We've talked about it at length. Copyright runs in, whether it's 3 seconds or what, you are not allowed to use it lah. But you can click share, okay? So we've answered that. In the case of the angry lady in the MRT with yellow umbrella, people make fun of her by making new priority seat images. Is the content creator wrong? Can the lady sue? Well, again, we discussed that earlier. I think it really depends whether she can be identified, whether it's defamatory. But I think the fact that she chooses to be in public, then she cannot stop people from making images of her per se. But if it's defamatory and there are no relevant defenses, then she could win, but it's whether she wants to go through the trouble of suing the content creator. What can I do if TikTok suspends me on an infringement that I'm not guilty of? Can I sue TikTok? The answer is no. If Facebook, TikTok, or Instagram or chooses to bar you from using their site, then it's too bad lah. You can't register yourself. You can't force people to let you use their products or their services lah, as far as I know lah. But you can post about it in another platform and get your 50,000 followers to try and pressure TikTok to return you your account, or use another email address to register an account. That's another way to do it. Yep. If we sponsor an influencer, can we control, dictate her script or to promote the product? The answer is it depends on the agreement that you make with them. And if you have an agreement that allows you to dictate everything and she agrees, then the answer is yes. Okay, that's all from me.
Well done, Paylin.
2 minutes.
Thank you, Paylin.
You deserve a prize for this.
All right, so we have to bring our Q&A session to a close. And at the end of this webinar, a survey form will pop up on your screen for your completion. We appreciate your comments as it will be used to improve future webinars. There are many more webinars as part of Law Awareness Weeks at CDC 2022. Please scan the QR code or visit the website bit.ly/lawcdc2022 to find out more about the other webinars. If you're facing any legal queries and keen to register for a legal clinic, please write to enquiry@lawsocprobono.org. We would like to thank Paylin and Wei Li for sharing their insights with us. And of course, last but not least, we would like to thank all of you for spending this Monday night with us, and have a good week ahead.
And also thanks to Serene for facilitating this. We didn't have
No
time to
worries.
talk, yeah.
Bye.
Bye, everyone. Thank you.